Hi, everyone. Good afternoon. My name is Chris Justice. I'm an employment lawyer with Samfiru, Tumarkin. And as always, I'm here today to hopefully answer as many questions as I can within the time permitted. So everyone out there, if you've got questions about your employment, maybe something's going on in the workplace, maybe you've been let go, you're wondering about a package that you got, perhaps you haven't yet joined the company and you've got some questions before joining, or maybe you've been presented with a contract and you've got some questions around that. Whatever it is, do your best if you can to get your questions in, and I'll answer them all here today live. But before we get some of those questions in, I just wanted to start off by talking about a few key things. Normally I'll bring up maybe a case that came across my desk, or just sort of do a refresher on an important subject within the employment field. This time around, I wanted to just quickly touch base on common law severance. There's a lot of questions, a lot of uncertainty, or maybe misunderstandings around how much severance is appropriate, whether the severance being offered by the company is fair, is sufficient. So hopefully I can clarify some of that today. A lot of times you'll hear this phrase, common law severance. What does that mean? And basically, common law severance is the amount of severance that the courts here in this province will try to determine. And in this particular case, for non-unionized employers, anytime that person is let go from their position. So if you've been let go from your job without cause, you've been offered a severance package. Most of the time when this happens, the company is going to of course, provide what's the bare minimum owed to you, but that's not common law severance. That would be severance owed to you under the legislation. And there's a difference between what the law says that somebody is owed at minimum versus what the law says somebody is owed at maximum. And the maximum part is what I'm talking about when it comes to common law. Common law severance is most often very much higher, significantly higher than just your bare minimum severance that you're entitled to. So there is that distinction between what the employment standards legislation says on one hand and what the common law says on the other. In the employment standards legislation severance, you're often going to be looking at how many years you've put in with the company that you're at. And that's typically what's going to be a main factor in deciding what the legislation severance that's owed to you would be, the bare minimum. But when you look at the common law and you're looking at sort of the maximum, the courts are going to look at a number of different factors to determine kind of how much you should get. So just like with the legislation, the years of service you have with the company is relevant. So that's one factor. But you've also got someone's age at the time they've been let go. So typically, if you're an individual who's of an older age, most often I would say in the 50s or 60s and beyond, you'll see that these people tend to get a little bit more severance than someone who may have lost their job who's only in their 20s or their 30s or their 40s. You've also got the position that you had at the time you were let go as one of the main factors to sort of decide how much severance you're owed. So if you are somebody who they've got a CEO role, they've got a C-suite position, executive role, managerial role. A lot of times, the more seniority, the more sort of prestige, responsibility that you have in the role, typically will lend itself to leading to more severance. Versus if you've, let's say, got a job that's minimum wage, maybe doesn't pay as much, less seniority or less responsibility, then typically that's going to mitigate against giving someone more severance than less. So you've got your age, you've got your length of service, you've got the position that you have with the company at the time you're let go, and you've also got the availability of similar employment to the one that compared to the job that you had that you lost. And so the whole exercise or the whole question is sort of revolving around, if somebody in your situation has lost their job, how long should it reasonably take for you to get the next job? So that's why, higher positions, there's maybe not going to be as much out there, not as much available. Someone who's older, they may not get a job sooner than later because an employer may think, I don't want to hire this person. If someone's making a lot of money in their job, again, that's going to affect the availability of what's out there that is comparable. And the longer someone's been at a company, if you've been at a company, say, for 10, 20, 30 years and you've lost your job, you essentially haven't been out there looking for work in many, many, many years. So it's going to take someone in a lot of cases time to kind of recuperate, kind of recollect their thoughts, maybe update their resume, maybe get some workshop lessons, this kind of thing. So that's partly why the amount of time someone's at a company before they lose their job is relevant when it comes to that common law severance. Now, those are the four, I would say, main factors. There are other factors that can influence how much common law severance you can get that may not apply to every case, but could apply to your particular case. So some examples of that would be if you have lost your job and at the time you lose your job, you're disabled or you're going through some health issues and you can't actually look for work and you've got the support or the backing from your doctor, then on a case-by-case basis, the courts are going to assess how much that disability or your health condition affects your ability to go out there and look for work. Or maybe you've got childcare duties or you've got other things going on in your life that could potentially restrict or limit your ability to find work sooner rather than later. Those are going to be other factors that can apply on a case-by-case basis. So at the end of the day, even though there are a few main factors that the courts look at when sort of figuring out how much common law severance should this person be owed, there are also multiple sort of case-specific factors that could play a role. And it's all important because under the legislation in Ontario, again, we're looking at the bare minimums. The most in Ontario you can get, no matter how long you've been at a company, is sort of going to be around the 7 or 8 month mark. And that's for long service people in particular. But when you flip it to the common law severance side of things, rather than your best case scenario being 7, maybe 8 months, the common law potentially can award you triple that, up to 24 months of severance. And so that's, again, why it's so important to figure out what your common law obligate or entitlements are versus just the bare minimum, because 24 months obviously is going to be a heck of a lot more than maybe someone being limited to only 7 or 8 months. Now, another question that people ask me when sort of figuring out, what common law severance am I owed? What is my potential? I'll go through with them these factors, but I will also make a point of saying that there are two main ways, even with all of those factors in place, long service, older age, senior position. Even if you have all of those in place, you might be looking at a high potential, but if you, on the other hand, lose your job and find another job relatively soon after, that's going to affect your common law rights. So, someone who is unemployed, let's say for 2 years after they lose their job, is going to get probably more severance than somebody, everything else being the same, maybe is only unemployed for 8, 9, 10, 11, 12 months. So usually once you find your next job, especially if it's a job that pays roughly the same or better than the one you lost, the courts are going to say at that point, whenever you did start that job, your common law entitlements would end, because at that point you've got a job, you're making money. And so from the court's perspective, there isn't going to be financial loss to you in terms of from that point moving forward. So finding work, that can affect your common law entitlements. The only other main thing that could affect your common law, even if, let's say, you don't find a job, is whether or not you've signed a contract with your company and what that contract specifically says. So you could be at a company, for example, for 30 years. You could be let go without cause. There's no cause being alleged, and you're being offered a severance package. But because you signed a contract with the company maybe years before that, and because there's a termination clause in your contract, that could also limit your entitlement. So it's very important in any situation, in order to figure out how much common law severance you're owed or what the potential is there. It's important for you to make sure you look at your contract, have an employment lawyer look at your contract and sort of assess, does this contract limit you in any way, or is it silent on the issue of termination? The other thing too to remember is that even if you have signed a contract, even if that contract does have a termination clause in it that is sort of trying to limit your entitlements, that's not an automatic assumption that that's the case. In fact, most contracts I look at when I'm sort of looking to see what the termination section says or how it's worded is it's not worded in the way that it should be for the company's benefit, which is ultimately to the employee's benefit. So you don't want to assume just because there's a contract that you're dead to rights. Most of the time, you still have that massive potential in terms of common law severance. But those are sort of the main two things: finding work and just depending on whether you've signed a contract and what it says. So other than that, though, again, your common law potential is upwards of 24 months. So you don't want to be definitely signing off on any package or accepting any severance offer, thinking it's fair, thinking it's reasonable, because a lot of times checking into it after the fact, you soon then realize that you actually shouldn't have signed it, and you kind of left maybe thousands or tens of thousands of dollars on the table as far as negotiations are concerned. So that's sort of a main little primer, I think, about severance. Now, the one other thing I wanted to just touch on before I get into some of the questions was there are situations where an employer will offer you, let's say, 24 months, 22 months, 20 months, something, let's say, that looks very good. But then when you actually look into what's being offered, you realize that the company is only giving you severance based on maybe your base wage. They're not including anything in terms of things like bonuses, commissions, stock options. So a lot of times, depending on who you are, your compensation may include a number of things, not just your base salary or your hourly rate, but all these other aspects along the lines of the bonuses, et cetera. So even if a company does offer you what looks like on its face to be a fair severance package, in terms of the number of months that it's offering, it may not be offering you a fulsome severance package. It may be forgetting to include one or two or three things that you ordinarily would have received had you still been there. And in the case of bonuses, depending who you are, that can often amount to tens of thousands of dollars on its own. So you want to look as well, not just at the length of severance that's being offered, but sort of all the particulars, the ins and outs, to make sure that it is a fulsome or as fulsome as possible of a severance package. We also at our firm, for those that don't know, have a severance calculator. So it's a relatively simple tool that we use where you can kind of input certain statistics or factors like the ones I mentioned: how old you are, your position, how long you've been there. And the severance calculator will give you a general range of what you could get under common law. It's not to say that that's the be all and end all, but that should give you at least an idea of the ballpark that you would be in if the company had offered you your full common law severance. But with that said, I'm just going to get into some of the questions as they've come in. I've got one in from Wayne on Facebook who's asking, what if you work only weekdays, 8 to 5, and now they want you to work extra Saturdays as well at another location that's about 25 kilometers away? Do I have to agree? So it's a good question. I think that anytime you've established with your employer a certain set of terms of employment, so it could be working 9 to 5, working 8 to 5, Monday to Friday, maybe you're working at a specific location, and then all of a sudden your employer comes to you and starts making changes without your consent. That's something that you need to be live to, because anytime a company makes a significant change to the terms of someone's employment, that can be considered a constructive dismissal, and that can essentially amount to a termination at law. So for example, an easy example, not quite what Wayne said, but if I'm making $100,000 a year and my boss comes to me and says, I'm going to cut your salary in half, I don't have to stand for that. I can take a stand and say, that's a breach of the terms of my employment. You know, I signed up to do this job. I agreed to get paid the following amount, this, and this, and now you're chipping away at it. I don't agree. So either reinstate me to that pay, otherwise I'm going to leave. And it sort of affords someone an option to almost leave the workplace or resign, but still be able to claim or go after the company for severance, because the resignation was specific to them making those significant changes to your employment. And even after going to them and saying, I want you guys to reinstate me back to this or that, they're just saying essentially it's our way or the highway. Well, again, you have a decision to make. Either you accept that, in which case that now becomes a term of your employment. It's going to be very hard, if not impossible, to revert back. Or, as I said before, draw a line in the sand, say that's not what I agreed to. There's nothing that I've signed that sort of allows you to make these changes. I haven't consented to it otherwise, and I'm considering that to be a constructive dismissal. So in Wayne's case, asking to work extra Saturdays, and then on top of that, working at a location that's 25 kilometers away and is going to add time onto the commute. Those two things combined could very well amount to a significant change overall, which would then lead you to that constructive dismissal argument. So there are options. I would say in Wayne's case, or anyone's case where there's a big change that's being made, or what you think is a big change being made, before you communicate to your employer that you are, let's say, resigning or you're not coming into the office based on these changes, I would still suggest you give us a call, get some legal advice, because it can be tricky. It's not always a black and white situation, but on its face, in a case like Wayne's, that could easily amount to a constructive dismissal. I've got another question in from YouTube. It's asking, when the employee has a duty to mitigate, can the employer give a negative reference? What are the remedies? How does this affect damages? And what if the employee has no disciplinary history? So just first, the duty to mitigate. So that is the duty to, after you've lost your job, go out there and try and find a replacement job. So that's a general obligation that's on anyone who's lost their job, depending on, assuming they can actually look for work and there's not a health issue at play. But that's what I was referring to earlier when I was talking about common law severance, and the idea that if someone gets a job elsewhere after they've lost their job, that can affect potentially how much severance you can get. So there's an obligation to look. If you do look for work, in other words, if you do try to mitigate your losses, but you're not successful, then that's what can probably give you more leverage to get more severance the longer that you're unemployed. And then if you do find the job, depending again what it looks like, that could also affect your severance. Now, as far as an employer giving a negative reference, it's going to depend on what exactly is said in the reference itself. So it could be, for example, the case that an employee doesn't have any disciplinary history, as far as maybe there's no written warnings on file, they were never given a performance improvement plan, and yet they lose their job and the employer is just telling them that they don't think they're the right fit, or that they had maybe some issues with the performance that weren't major, but big enough for the company to just decide to let the person go. So even if you don't have sort of written disciplinary history, it is still possible that the employer may think that you weren't perfect, that there were some negatives with respect to your job. So again, it kind of depends on what's being said. There's nothing illegal on its face about an employer giving a negative reference. Certainly if the employer is slandering that person, or there's an issue of defamation where the employer is sort of making up negative reasons that don't actually exist, and communicating that to one or more other potential employers, then that company that's giving that negative reference could be in a little bit of hot water, to say the least, depending on what they've said and the truth of what they've said. So there could be damages potentially owed in some of the more, I would say, extraordinary situations. But also, if an employer gives somebody a negative reference, the idea would be that it's not going to be very helpful in having that employee then land a new job. So if an employer gives a negative reference, and as a result of that, it takes much longer for that employee to find another job, then the employer is not going to be able to, of course, take advantage of the fact that you found another job to chip away at your severance. So as much as the employer may want to give a negative reference, it could, in the long run, actually end up to them paying more in damages, wrongful dismissal damages, as far as severance is concerned, because it's likely going to take you that much longer than to find another job. So it is kind of connected to how much severance someone can get, a negative reference, but it also, depending on how egregious or bad faith the negative reference is, you could be also looking at damages above and beyond just your regular severance. So it'll just kind of come down to a case-by-case basis. but I appreciate the question. I've got another one in from Daniel on YouTube who's saying that their employer deducted money from their paycheck for mistakes that Daniel may or may not have made at work, and Daniel's asking if that's allowed. So in general, the short answer is no. Employers cannot deduct money from somebody's paycheck. An employer cannot maybe pay somebody money and then after the fact come back and request that that employee pay them back a portion of maybe a wage check that they received. The law generally speaks to that and says that that's not allowed. And in fact, if you're an employer and you're deducting money from employees' paychecks, even if you think it's justified because some mistake was made at work, that's in most cases going to be a violation of the legislation. So there's certain regulations and laws under the Employment Standards Act, for example, in Ontario, that look to prevent these deductions from happening. So that would be, in most cases, a violation of the legislation. And by an employer deducting money from someone's paycheck, that's also potentially a significant change to the terms of their employment, going back to my comment about constructive dismissal. So the deduction itself could amount to another version of a termination at law. So now the employer is not only sort of on the hook or in hot water about making the deductions, but they then also essentially terminated the employee when they did that. And now they're exposing themselves to upwards of 24 months of severance, depending on what the factors involved in that employee's case are. I've got another question in from Sarah on Facebook, who's just asking how they get into contact with a disability or employment lawyer intake team. So we at the firm itself, Samfiru Tumarkin, we have a team of lawyers both on the disability and the employment side. Sometimes your case may involve a bit of overlap for both, but we do have lawyers in both areas. So if you give our office a call, that'll generally get directed to intake. Intake at our firm will then take down your information, your details, sort of get a bit of a summary of your case or your situation of what's going on. And then a lawyer from that point would get assigned and there would be a consultation set up. So again, that could be on both disability employment or either or. So I would just recommend you give us a shout on the number below and then we'll assign somebody to you. You can have a chat with that person. And then from that conversation, we can definitely tell you whether you have a case, sort of what the value of the case is, maybe what some roadblocks could be going forward, just so that you can make, I guess, as best informed of a decision as possible. So just give us a call and we can definitely get you in touch with the right people. I've got another question in from Victor on Reddit, who's asking or saying that they were let go right before the commission was due to be paid. Can my employer withhold it? So it's a good question. A lot of times I find it could be a commission, could be a bonus, but there's an idea of, okay, I'm going to get paid a bonus on such and such date. And then you find yourself without a job a day before the bonus gets paid out, or a day before the commission gets paid out, or a week before. And then you think, well, the timing of it is looking very suspicious. Did they do this to try to avoid paying me it? Because in a case of like a commission or a bonus, even though a bonus may typically get paid out, let's say once every year in February, it's usually going to be based on your performance for the prior year. So if I work 2025, I earn my bonus, my numbers are good, I'm supposed to be getting a bonus, I just have to wait until it gets paid out. And then come January or early February, I lose my job right before the bonus or the commission's paid. A lot of times companies are going to say, well, you weren't here on the day that it was paid, so we don't have to give it to you. But meanwhile, you put in all the work for the previous year. You essentially earned the bonus. The only thing that you're waiting on is just the timing of the payment. And in most of those cases, even though employers try to get away with paying commissions, they can't, because essentially you've earned that bonus. And that's another example of where somebody will be let go and then they'll be offered a package, but then lo and behold, you don't see your commission check or your bonus check, even though you've earned it. Maybe you've put in the hours for the previous month to be entitled to it. So I would never assume that just because you get let go before a bonus or a commission is paid out, that somehow the company has an out not to pay you. as I say, in most cases, it's still going to be payable. And if it's a big commission or a bonus, it's not something you want to let lie, and you should definitely follow up, or certainly schedule a consultation with us, and we can kind of take you through what the employer is saying, what chances they have of even being able to win an argument like that, or just advising you that, no, you are entitled to that. That's within your rights. But it's a good question. It does unfortunately happen a lot where someone is let go right before payment is given. I got another question on Instagram from Renee, who's saying that they were fired without cause shortly after returning from a medical leave. Is that a wrongful dismissal? So the short answer to that is maybe. It could be. I mean, certainly the optics don't look good. You come back from a medical leave and then you find yourself without a job, and you're asking yourself, why was I let go? Was I let go due to the fact that I went on a medical leave? Was I let go because maybe I've come back from a medical leave and I'm asking my employer for accommodations because my doctor is saying, I can come back, but just maybe with some accommodation. Some employers may think, no, I don't want to bother with that. I don't want to deal with that. That's a burden. That's an inconvenience. So I'm going to let them go. That can very easily be a human rights violation. But essentially the question that gets asked here to sort of figure out, am I entitled to, let's say, punitive damages or human rights related damages? The question would be, had I never gone on medical leave, would I have still lost my job? Because if going on that leave played any role in losing the job, even if it's just 1% of the reason why you lost your job, then that would be a human rights violation. You'd be looking at human rights damages. Obviously, you'd be looking at your severance and trying to make sure that the severance is otherwise fair and reasonable. But I guess technically there are situations where someone could be let go after they've come back for a leave that is entirely unrelated to them taking the leave. It's just, in a lot of cases, I don't think companies have the best argument or the best rationale in proving that. So it does raise alarm bells in my head whenever those sorts of things happen. Also something that you should give us a shout about so we can kind of go through and flesh it out and figure out just to what extent you are entitled to damages, let's say above and beyond your standard severance. Got another question in from Katie on YouTube, who's saying that they're on LTD, they're working limited hours. If they're terminated, can the insurance company reduce pay if I get severance or a settlement from human rights issues? The answer is yes, potentially. It would depend on the insurance company's policy. Sometimes the insurance company will have a policy where it says, you're let go. So let's say you continue to collect your LTD. Now, LTD, the purpose of LTD is to replace your lost wages, usually due to a health-related issue. Severance is also circling around the idea of compensating you for lost wages. So if you lose your job, then most of the time you're going to be owed severance. And the same factors apply, age, length of service, position, all these sorts of things is going to figure out how much severance you're owed. But if you collect severance from being let go, and at the same time you're getting LTD that's sort of overlapping with the severance that you got, because both those things are aimed at bridging the gap until you find your next job, or replacing your wages due to not being able to work. Most of the time, there's going to be some offset in the policy that says, well, there's no double dipping. So, and this happens also with EI. So if somebody collects, let's say, $10,000 in EI, but they also get $30,000 in severance over the same period of time, EI is in most cases going to come to you and say, we want our 10 grand back. The same general idea, I think, applies to LTD if the policy says as much. So there just can't generally be that double dipping, but it's also not a black and white thing. So it kind of depends on the wording of the contracts, the insurance policy. Now, if you get human rights damages, even if you also collect LTD, that could be a slightly different scenario, because human rights damages are meant to compensate you for the violation to your human rights, and they're often paid on a tax-free basis. So there's probably going to be a better chance that if you get human rights damages and those overlap with some LTD or severance that you got, there's probably not going to be as much of an onus on you to have to pay back any money or get shortchanged in that sense, because the purpose around the human rights damages is going to be different than what's normally the case with severance or long-term disability payments or EI payments. So hopefully that kind of clarifies things a little bit. I'll answer one more question just before my time is up. It's from Shobin, who's saying that their husband works in a sales role. His employer recently told everyone that they're changing the comp structure, dropping commissions for everyone. How much are they allowed to change? So again, this goes back to the issue of constructive dismissal, significant change to the terms of your employment. Now, when it comes to changes to your employment on the financial side of things, typically the courts are going to consider anything at least 10, if not 15% and higher of a pay cut. So for example, if you're making 100 grand a year and your company comes and says, we're changing this, that, and the other, and now you're only making 80, well, that's 20% hit. Or you're making 85, that's 15% hit. That on its own is likely going to amount to a constructive dismissal. If you're making 100 grand a year and your employer changes things around to the extent that you only get dinged maybe 5 grand, and it's only 5% of your overall pay, that probably will not be enough on its own anyways to trigger a constructive dismissal. I think the percentage has to be generally a little bit higher than that. So if we're just talking changes to finances specifically, you kind of want to keep in mind that 10 to 15% drop. When you're in that range, you have a much more arguable case than if it's a bit less, even as frustrating as that may be to hear for some of you. But as always, I'd say give us a call. And like I said before, we can kind of flesh it out in a consultation. But thank you for your question nonetheless. Again, something that I think affects a lot of people, so I'm sure it'll be helpful. But that does it for my time today, everyone. I do appreciate all of your questions, everyone showing up. For those that I didn't get around to answering or maybe had follow-up questions, just feel free to give us a shout. We can schedule a consultation in any event, or as it says down below there, join another Q&A that's going on tomorrow, in fact, February the 3rd. So that's 1 o'clock Mountain Time with Karen. So for all of those that I didn't get around to, or maybe have questions that didn't ask them today, you can tune in tomorrow with Karen, and she'll, I'm sure, do her best to answer everything. But thanks again for everyone's time. I do appreciate it. And I hope you have a great rest of your day. Thanks. Bye for now.